We're just going to give it one more minute to make sure that everybody's here who's going to be here. Okay, I think we can go ahead and get started. I appreciate everybody being here today. I'm Tim Barker, our district attorney for York County, and the reason why we're having this press conference today is due to an arrest that we had made on Reed Davenport from Maryland, and this is concerning the killing of Philson Heinbaugh, Jesse McKenzie, and Robert Hamp last year to the day on April 17th, 2024 at approximately 3:25 a.m. on Interstate 83 South at approximately mile marker 35.5 in Fairview Township. If you recall, those three individuals, Mr. Heinbaugh, Mr. McKenzie, and Mr. Hamp, were working in their official capacity as construction workers in an active construction zone. The work zone was active at the time, and it was properly set and properly equipped when they were killed by Reed Davenport, who at that point in time was operating a box truck in his official capacity as a commercial motor vehicle driver, as he was engaged as part of his runs that he was doing that way in making deliveries for his place of employment. This has been a lengthy investigation, and I want to begin by discussing that. We are here a year later, but it's not due to the lack of great diligence and great pursuit of the truth that took place in this case by the Pennsylvania State Police in conjunction with our office. It's due to the complex nature of vehicular fatalities, especially when they involve commercial motor vehicles and commercial motor vehicle drivers. The simple reality is there's a lot of information to gather, and that can take a while to do. And in this particular case, after the evening of the crash, there were multiple different efforts that were undertaken, as you can tell from the affidavit of probable cause. And I do want to mention at this point in time, please remember again, this is an arrest based upon probable cause, but this is not guilt beyond a reasonable doubt at this point. The defendant, Mr. Davenport, is presumed innocent until we prove him guilty in a court of law beyond a reasonable doubt. And that is what we do intend to do. We believe that the evidence will sufficiently establish his guilt beyond a reasonable doubt. But this time he is still within the cloak of innocence. He is still presumed innocent. So what were the steps that were undertaken to get to this point? Besides the initial scene evaluations and being taken, Mr. Davenport being taken to have his blood drawn, to be checked to see if there were any illegal substances or impairing substances that existed. There was an interview that was done with Mr. Davenport, as documented within the affidavit of probable cause. But then there was a further complex collision reconstruction that was performed by Corporal James Mooney, who's an expert in collision reconstruction with the Pennsylvania State Police. There's toxicological findings that occurred where Dr. Stephanie Marco with NMS Labs had undertaken that effort. And then there's further documents to be gathered. And I'll freely admit, as being the individual who kept requesting more and more documents, it's because of knowing what it takes to make sure you're getting to the actual truth in commercial motor vehicle crashes. We needed documents regarding the history of Mr. Davenport as a commercial motor vehicle driver. We needed to explore the history of his CDL. We need to know more specifications about the commercial motor vehicle itself. We needed to know more about the medical certificate history and about the medical exams and any prior drug testing that had occurred regarding Mr. Davenport. We need to know what his acquisition of knowledge was when it comes to the operation of a commercial motor vehicle. And then finally, based upon that information, we realized that we need to have a supplemental forensic toxicology report that was going to go ahead and discuss even further what is the actual interplay that would exist between marijuana and fatigue driving. We obtained that report this week, and immediately thereafter, upon reviewing that information, we were able to reach our conclusion and file charges. So what are those charges? They include 3 counts of murder of the 3rd degree, 3 counts of homicide by vehicle while DUI, 3 counts of homicide by vehicle being committed in an active work zone, 4 counts of DUI involving subsections related to marijuana consumption and marijuana impairment, 1 count of recklessly endangering another person because there was another vehicle at the site of the scene, a Ford Edge, that the defendant struck. And inside was an individual named Christopher Louch, who, while he was not injured, he was in risk of being seriously injured. And by that conduct, we did charge recklessly endangering another person as relates to Mr. Louch as a victim. We also filed 11 summary offenses. Some of these summary offenses are ones you commonly see in vehicular homicide cases, such as careless driving, 3 counts of careless driving unintentional death, reckless driving. Then we also filed 3 counts of duties of drivers in construction areas, and the reason why it's 3 counts is there's enhancements for those offenses based upon death being caused, and it attaches to each individual who's killed. And then we also filed 3 summary offenses that specifically relate to obligations that a commercial motor vehicle driver has with regards to their knowledge and their requirements that they do not operate a commercial motor vehicle while impaired from fatigue and while impaired from controlled substances, as well as the duty you have when you obtain your CDL and the training that you have to not violate that training and that knowledge as well, which relates to the licensing citation that we had also filed in the violation therein. Those offenses are extremely important because of what they establish of the special knowledge that Reed Davenport had in operating this commercial motor vehicle. Reed Davenport, as the affidavit of probable cause shows and expresses, he was a CDL driver, and he was operating his commercial motor vehicle that he was operating for employment. And his route of travel that he did on this evening, beginning in Upper Marlboro, Maryland, his first stop then was to Hagerstown, Maryland. Second stop is at Falls Church, Virginia. And then his third stop was Frederick, Maryland, and then his 4th stop was New Columbia, Pennsylvania. And he's actually traveling en route with his 5th stop. So this is the amount of distance that is being traveled, the significant amount on this occasion. That becomes important because also of what Mr. Davenport said his condition was while he was driving. While he denied using any controlled substances, which was disproven by the toxicology, finding marijuana and specifically the impairing ingredient of marijuana, delta-9 THC, in his system, and that substance would be related to him being impaired by marijuana. He also, by his own admission, had not slept for approximately 24 hours before driving his vehicle and did tell troopers that he, in fact, was fatigued from driving and, to the best of his knowledge, had blacked out prior to this collision. Now, part of the affidavit of probable cause, and I want to make specific reference to this portion, and intentionally we put all of it in its entirety into the affidavit, was a summary of the collision dynamics in this case. Corporal James Mooney, is part of what his role is as a collision reconstructionist, not only did he have to determine what the collision dynamics were, how this crash happened, but also what caused this crash. And he stated very succinctly in his summary, this collision occurred as the Freightliner, which is the vehicle operated by Reed Davenport, was traveling south on I-83 in the right lane approaching the active work zone. The International was legally parked in the right lane with the Scorpion crash attenuator down and the arrow board lit directing traffic to move to the left lane. Commonly, that's referring to a signboard that all of us have seen when we approach active work zone sites. The signboard was up and lit and in its proper legal placement. There were construction workers in front of the International actively working on the roadway. The Edge that I had referred to previously, which is the vehicle that Mr. Lausch was in, that was on the right shoulder in front of the active work zone. There was a second truck in front of the International with an arrow board directing traffic to the left lane with a Scorpion crash attenuator down. So we have secondary signage as well. In front of the second crash truck was a work truck used for filling cracks on the highway with two large lights on it. The Freightliner, operated by Davenport, traveled into the right shoulder and sideswiped the International. And by the way, not only did we know this through the evidence on the scene, but as also indicated from the affidavit of probable cause, there was a FedEx truck which had a front dash cam that was working and operational that actually captured that point of impact when it had occurred. And you can see Mr. Davenport's vehicle go ahead and strike the signboard truck. The Freightliner continued along the right shoulder and struck three construction workers, McKenzie, Heinbaugh, and Hamp, killing all three. The Freightliner then continued along the right shoulder and entered the grassy median, striking the embankment. The Freightliner then sideswiped the Edge. After striking the embankment, the Freightliner then crossed over the right shoulder, right lane, and left lane, striking the concrete longitudinal barrier, coming to an uncontrolled final rest, touching the concrete longitudinal barrier. That is where the vehicle came to final rest upon its impact. And the key term there, uncontrolled. This was not a controlled stop by Mr. Davenport of his vehicle. This was an uncontrolled stop that was only caused due to the numerous impacts as well as finally coming into contact with the barrier. Davenport was traveling 63 miles per hour as it approached the active work zone. The Freightliner began to slow when it struck the International at 50 miles per hour. Davenport never applied the brakes after initially striking the International, and in fact did not apply the brakes until after the Freightliner was at final rest. Again, further evidence that this was an uncontrolled stop, not a stop that was conducted by Mr. Davenport. At the time Davenport was operating the Freightliner, he was under the influence of marijuana. And this impairment, not only is this an impairing substance in and of itself, and as we detailed from the supplemental report of Dr. Marco, how marijuana impairs one's driving function, but also the role that it can play in conjunction with fatigue and how it may increase impairment, and you can have substantial impairment in and of itself caused by extreme fatigue. As Corporal Mooney continued, Davenport, under his own admission, was also tired and operating the Freightliner without having slept in the previous 24 hours. The ECM data, that would be the data captured by the vehicle that we're then able to download and analyze, which did occur in this case. Of the erratic throttle applications, indicates that Davenport was not coherent when he was traveling towards the active work zone with little to no traffic in front of him. So essentially, this erraticism shows your lack of being coherent and your lack of being able to maintain proper operation and operability of your vehicle. And there was very little traffic at that time of night, which, even though it's I-83, still you're talking the early morning hours. And therefore, because it was so late in the evening like that, traffic was lessened. So this is not a stop and start situation that sometimes you encounter on I-83 during rush hour time periods. Davenport's operation of the Freightliner under the influence of marijuana while also failing to get enough sleep is the reason he traveled into the work zone, striking the International and killing Mackenzie, Heinbaugh, and Hamp. That was the conclusion of our collision reconstructionist. The important part about that conclusion and the important part about this reconstruction is that it shows that Reed Davenport, based upon his impaired and fatigued state, did directly and substantially cause the deaths of Mr. Mackenzie, Mr. Heinbaugh, and Mr. Hamp. What we need to establish for the crimes that we charged, we need to establish for homicide by vehicle, recklessness as the mental state, as well as other violations of the vehicle code. For homicide by vehicle while DUI, we need to establish criminal negligence, but also that the impairment was a direct and substantial cause of death. And for homicide by vehicle, we also had to establish that this is an active work zone in order for this to be enhanced under the active work zone enhancements. And we also need to establish that those underlying summary offenses, excluding DUIs, that the other underlying summary offenses were a direct and substantial cause of death. Then when we get to murder of the third degree, we need to establish recklessness with extreme indifference to the value of human life, otherwise known as malice. And that's really what malice is. It's not merely a hardness of heart, cruelty, wickedness of disposition. Those can be malice. But really what malice is, it's recklessness with extreme indifference to the value of human life. Another way to put it is this: it is a conscious disregard of a known and unjustifiable risk that death or serious bodily injury could result, and that the conduct engaged in was a gross deviation of the standard of care that a reasonable person would undertake. That threshold, we assert, has been met. And the reason why that has been met is not merely because, and when I say merely, I'm saying that legally, not because driving while impaired is a mere offense. It is not. But under the law, that does not equal, in and of itself, third-degree murder. Violating other provisions of the vehicle code while doing so recklessly does not equal third-degree murder. So what is it that takes us up to recklessness with extreme indifference to the value of human life? It's the combination of all factors. It is the fact that we have an individual who, after having not slept for 24 hours and with the impairing impacts of marijuana in his system, drove many, many miles in the course that I previously mentioned as detailed in the affidavit of probable cause, and then finally coming towards the end of the run, while admitting he was in a state of extreme fatigue, without any attempt at evasive actions, drives into an active work zone that was well and properly lit and kills 3 individuals and put a 4th in harm's way. And as a CDL driver and a person operating a commercial motor vehicle in his official work capacity, he possessed that special knowledge that you have from training, above and beyond common and ordinary knowledge about impaired driving or fatigue driving. There are specific provisions as detailed in the affidavit of probable cause as well as in the complaint that relate specifically to your obligations and the knowledge that you have regarding the fatigued driving condition and the impaired driving condition, and the consequences that will result when you operate a vehicle in that way. Yes, the great probability that you have, the extremely high and unjustifiable risk that serious bodily injury or death will result if you operate a commercial motor vehicle, a 26,000-pound vehicle. Again, when we think about it in those terms, any vehicle is of substantial size. When you're talking about commercial motor vehicles, you get even more substantial in size. This is a 26,000-pound vehicle when it's not loaded. This vehicle was operated in such a fashion that with most certainty it would kill anyone that would be in its path. That is a sustained recklessness. That is, we assert and we will prove, is recklessness with extreme indifference to the value of human life and does support murder of the 3rd degree. We do not make that charge lightly. We do not make any charges lightly. It's the reason why we had to so carefully and so patiently wait for all information. If we did not have this thorough an investigation, then we would not have gotten to the truth of what occurred, and we would not have properly and appropriately charged this particular case based upon evidence and law. And we do understand and greatly appreciate 3rd degree murder is to be the exception. It is a rare occurrence in the area of vehicular crime. And we most certainly are not asserting that just because a commercial motor vehicle is involved in a fatal crash, that equals murder of the 3rd degree. By all means, we are not saying that. We are saying that this case, under these circumstances, looking at all of the evidence together, that it equaled recklessness with extreme indifference to the value of human life and therefore merited murder of the 3rd degree. I would like to thank the great work that has been done by the Pennsylvania State Police. Trooper Galbraith, he was the affiant on this case and the lead investigator. Trooper Coulter, Trooper Daldo, Trooper Lockman, Corporal James Mooney, the extensive work that he did in collision reconstruction. We appreciate the work that NMS Labs had done, the extra work that we had requested, and what that information then was able to tell us. We are very appreciative for all of the hard work of our investigators. I also greatly appreciate the hard work of our fellow prosecutors in our office and the assistance of our county detectives as well that they gave us, and also of our victim witness unit. Clearly, in being here on the 1-year anniversary today, the devastating impact that clearly the victims' families feel and of what they're going through, and the fact that we had to put them through a year's worth of wait to be able to tell them a complete truth, we don't, and I do not take that lightly. I understand that every day is another day where you can compound trauma, and we did not put them through that lightly. But we had to get to the truth. We had to. You know, there's this expression called justice delayed is justice denied. It's a cute little catchphrase, and it's false. Not doing everything you can to pursue the truth to the lengths you have to pursue it, that denies justice. And as I said at another time in another circumstance, there are times when justice needs to rest, but justice never goes to sleep. And it did not go to sleep here. And this was always on our mind. And we pursued this with all of the diligence that we possibly could. And we made our charging decision detached from any emotion, as we're required to do. We're human beings, but we have a job. And we did that. This is not based upon any emotion or any internal feeling or belief. We had to make this decision based upon fact and law. And we assert that we have obtained that. And we are ready to proceed further with charges. Our next stages that will occur, the arrest was effectuated today. Mr. Davenport, through his attorney, turned himself in, and he has been processed, and he has been transported to York County Prison. Mr. Davenport is not entitled to bail, because the maximum sentence allowable by law in this case, due to the fact that there are 3 counts of murder of the 3rd degree, should he be convicted of those 3 charges, then there is a mandatory sentence of life imprisonment without parole that would result. So therefore, constitutionally, he is not entitled to bail. We will continue to analyze and evaluate the appropriateness of any sentencing considerations in conjunction with our discussions with the victims' families. This is not the time or place to do any such discussion or review. And it's premature to go any further than what I just discussed as what is potentially there. And I only mention that because of its interplay with bail and the reason why Mr. Davenport is being held at York County Prison. But as I do mention, he did turn himself in, and I will state we're very appreciative that he cooperated and did so. He's a Maryland resident. We could have been required to go through an extradition process and do service in Maryland, but through his attorney, he agreed to come up to York County, turn himself in, be processed, arraigned, and be committed to York County Prison. One of the aspects that we do want to say, and I'm going to separate this apart from any discussion of the facts of this case. Again, Mr. Davenport's presumed innocent. He will not be guilty of these charges unless and until we prove him guilty in a court of law beyond a reasonable doubt. But there are some general things that we can discuss and take away, which are these. First of all, every time a construction worker goes out into the roadways, he has a probability of dying. He or she faces danger. They're doing work for us so that we can go from place to place, not just with convenience, but that we can get there safely. They're serving us. The least we can do is always remember that. And when we approach a construction zone, when we approach construction workers, that we do so understanding that their lives are in danger and acknowledging and respecting our responsibility to serving them for serving us by being safe and cautious and prudent when we are in work zones. How much is it to ask of any of us generally than to slow down, pay attention, be careful. That's a very simple ask. Second is this. Fatigue driving is impaired driving. If you're too tired, pull over. And third, yes, there is such a thing as driving while under the influence of marijuana. In fact, we see it frequently in York County. It's the #1 controlled substance of choice when we see DUI drug cases, and it's not even close. The percentage of cases that marijuana is either by itself or in conjunction with other drugs is the impairing substance. It's vast. It's vast. Of our repeat offender, multiple offender population within the 10-year look-back range, we always average around 60% of those DUI cases have a drug on board. And the greatest percentage by far is marijuana. If you're driving after consuming marijuana, you are running the risk of going out into a roadway and seriously injuring or killing yourself or someone else. We tend to take marijuana for granted. We talk about it casually. We talk about it like it's not something that's really dangerous anymore. And when we approach something that can impair you that substantially behind the wheel, or can cause many other factors in life, including some of the other impacts we're seeing that are subject for discussions perhaps at another time, when we don't take that seriously, that's the time when it becomes the most serious. I've prosecuted too many fatalities where marijuana was a main aspect of impairment. We need to be very aware of what marijuana can do with regards to impaired driving. And again, I'm making those comments, not directly commenting on this case. But we do believe that from a societal education standpoint, that they are appropriate and that they are matters that will wind up potentially being raised as topics of discussion, as awareness in this area will continue to occur and hopefully continue to improve for all of our safety and for all of our benefit. At this time, that concludes the remarks and the comments that we have. Again, I greatly appreciate what the state police have done, their hard work and their hard efforts. Greatly appreciate what our office has continued to do in working on this case in conjunction with the Pennsylvania State Police. And we look forward to meeting our burdens not only at a preliminary hearing of a prima facie showing, but ultimately at trial of proving this case beyond a reasonable doubt. We thank you all for being here, and I'll now open it up to any questions that you may have about any aspects. Again, I will be keeping myself within the four corners of the affidavit, as is my ethical duty, but I open up now to any questions.
Other
Yes.
than this past day of him turning himself in, has Davenport been cooperative in the investigation?
So what I will say is this: he did agree to be interviewed. He did agree to a blood draw. And so he did participate in those aspects. Now, one of the allegations we make and how this is an interplay with your mental state, there's an instruction called consciousness of guilt. And it can be established by giving false or contradictory information to law enforcement during an investigation. And in this case, we do have a denial of having consumed any controlled substances. But as the toxicology showed, we did have both the active ingredient and the inactive metabolite of marijuana that was in his toxicology. So I think that's the best way for me to answer that.
Is the toxicology report able to determine how recently he consumed marijuana prior to the accident, or how strong the substance was found within his bloodstream?
So those are not answerable with regards to the toxicology. One of the things about marijuana, unlike alcohol, you do not have relation back. So there's something in alcohol that's called relation back evidence that you can do, where if you're able to gather a bunch of different factors, you can then go ahead and you can put together different information and get a range of what a blood alcohol level would have been at a specific moment in time. And that is not something that you have the same way with marijuana consumption. There are generalities that we know that are pointed out within some of the given reports and is in the literature of how fast it takes following ingestion of marijuana to dissipate through the system from smoking marijuana, how long it takes, what the curve is. Quite frankly, there's a very rapid decrease that does occur of the active ingredient of delta-9 THC that then tapers off in terms of its dissipation. Then there's some other roles that, depending upon your frequency of smoking marijuana, can interplay into some different aspects of when someone would have consumed the marijuana. The most important things that we have and what you really are looking for in comparisons is, what are the impairing natures and effects of marijuana? What is your driving conduct that you have here? The driving conduct you observed, does that have a relationship that it's consistent with the type of impairing impacts and impairing effects that marijuana can cause? And that's the same way with any drug. I'm mentioning marijuana here because that's the topic, but that's that way with any drugs or even alcohol, ultimately, that you're looking at. Do we have a relationship? Now, ultimately, the toxicologist talks about that relationship from a toxicological aspect. Hey, here's what marijuana does to the brain. Here's what it does to driving function. Here's what we found. There can be a consistency that does exist here. The person that has to testify to whether or not it's a cause of a crash by law is the collision reconstructionist, because they're the ones that reconstruct the crashes and get to the why did this occur. So they have to be able to know that interplay. Generally speaking, that's a field called human factors. It's like, why do human beings do what they do behind the wheel of a vehicle? So that's why it's called human factors. Well, any kind of impairment, be it from fatigue or be it from drugs and alcohol, falls under human factors. Other things do too. Distracted driving, that falls under human factors. Were you paying attention? Those are all human factors kinds of things. And of course, when you get into visual observation, things like that, that all can fall into there as well. So because of all that and its relationship with collision dynamics, that's why it's the collision reconstructionist then that takes all that extra information, refactors that all in. So it was very important to then be able to reconfirm that yes, the collision reconstructionist opinion on this accurately reflected what the toxicology was. Yes.
You had spoken about the complex nature of vehicular fatalities, and I understand that you were talking about that as for why it took so long. But really, if you could boil it down, kind of what was the most challenging part of this investigation? Obviously a year later, waiting to bring this forth.
Most challenging part is, and this is not to sound overly simple or trite, but the most challenging part really is figuring out what it is that you do not know. So after we got through the first leg, and it always takes a little while for full collision reconstruction to be completed. And the reason why it takes a little while, our collision reconstructionists that we have, they do a phenomenal job. And in Troop J, we have 2 excellent collision reconstructionists. They're responsible for all of Troop J. So needless to say, there's a lot of work that has to occur that is put upon them. Additionally, if you think about it this way, this is all science. This is all having to gather all scientific information. It's not just going out to a scene, walking around looking, making observations, saying, now I know. That's part of it, looking at the scene, but then you have to acquire all the downloads from the vehicles, all the technological information that way. You have to evaluate all that. You have to have the vehicle checked out by what are called MCSAP people. They're motor carrier safety inspectors. You have to go ahead and get their opinion on some functionality of vehicles. You have different safety aspects to look that way. Then when you get that, and here when we got the toxicology back, and when we got back the collision reconstruction report, then we knew, okay, now we need extra information regarding the driver himself. What was his driver experience history? What was his knowledge? What training did he actually have? What occurred at different points in the file? Was there information to know or not be known? There are things that, and they all have an interplay. Like the reason why it was important in the affidavit of probable cause to mention about when he had his urine screen regarding controlled substances, that occurred in January prior to him taking his job in February, and it was negative, is because we know what the time frame is that a urine screen covers, and it meant that he did not have marijuana consumption during that time. What does that do? Well, that's extra information that is important for consideration potentially in toxicology, because it tells us that this was not a years-long worth of everyday marijuana user. We would have caught that. That isn't the case. Well, what does that do? That can have different interplays regarding the impacts of impairment on an individual and on aspects of toxicological values and of things such as that. So gathering all of these records from all these files, saying what do we need here, what do we need there, continuously identifying further information you need, and then realizing we need to go back and run some of this further through the toxicologist to say, what are we actually looking at here? Because if we go ahead and we read it wrong, we can overcharge. Or we could read it wrong based upon other assumptions about things such as marijuana or fatigue, and we could undercharge, and we could have wound up just charging with homicide by vehicle. So that's the challenging part of all of it and why it takes so long.
Okay, and just going off of that a little bit, did you have the chance to speak with the employer at all? And will the employer also be facing potential charges in the future?
So we did communicate with the employer. We did make requests of the employer. As far as we are concerned, this matter is one of the commercial motor vehicle driver error. This is not one of company error rising to criminal conduct. Based upon our review of the records and our information we have from a company standpoint, there is nothing to establish culpability in that way upon the employer. So I have prosecuted employers previously, and in fact, the first case actually to prosecute an individual sole employer for homicide by vehicle in the country that we're aware of was actually in York County by me back in the 2000s. When we had the trial against Todd Sachs in 2007 for the fatal crash that occurred in Glen Rock on April 11th of 2003. So we know what we're looking for in those documents. It is something that if it's there, we have prosecuted more than one company already when they were responsible for the reasons why a crash occurred. That is very rare. Most companies are very responsible for the overall systematic running of their fleets, including pre-inspection, post-trip inspections, maintenance inspections, not violating on their own accord, like driver run aspects, timesheets, things of that nature. We did not see here any of those kinds of things that would be put on the employer to raise that level up to be criminally culpable. The responsibility that we found in this case fell on Mr. Davenport as the driver.
So he never asked his employer for permission to pull over if he was feeling that fatigue or impairment?
That is correct. We found no evidence of that.
Did he actually
And-
nod off or black out while he was driving?
He said that he did. What we will say is the evidence that we have shows that he lacked any coherency of what he was doing when he was going into, approaching and going through that active work zone. There were no evasive actions. There was no response or reaction by him. In fact, not even brake engagement until after his vehicle came to final rest. So there was a complete lack of any responsiveness or what we would call normal coherency while operating the vehicle. And that's why that was put in by Corporal Mooney. Mr. Davenport stated, as we have in the affidavit of probable cause, that he believed he blacked out and doesn't recall what occurred. The driving function would support that he was completely unaware, whether it was a blackout, as he said, or some other kind of unawareness that occurred. There was a lack of coherency, comprehension, awareness at all of what was occurring when he approached to and went through that active work zone.
Has Davenport ever been medically prescribed, have a medical marijuana card?
We found no evidence of that. If we would have found evidence of that, that would have been something even further that we would have had to explore. And clearly that would have been something we would have needed to have put in the affidavit of probable cause. That also creates, because not only could that be potentially exculpatory, but also that would be something that would lead to further investigation documentation regarding medical providers, and also the employer in and of themselves. We found no evidence of that. There was nothing to be documented with that, and in fact, Mr. Davenport himself said, "I do not use controlled substances."
Couple questions.
Sure.
He said he was up for 24 hours before starting his work shift at 6 that Tuesday night, going into the 9 hours after the 3 o'clock crash.
Yeah, his exact words, as we put it in the affidavit of probable cause, were, "I'm not going to lie, I am running on no sleep. I stayed up 24 hours yesterday."
So he was up from about 6 p.m. Sunday to start. I can't do that, I'm sorry. From
So-
about 6 p.m. Tuesday back to 6 p.m. Monday, I guess?
So the most sleep range that I believe that we have from him was when he stated, as we have here as well, that he slept through the night Sunday 4:14 into Monday 4:15. He took approximately a 3-hour nap before he went to work Monday 4:15 at 1800 hours, so that'd be at 6 p.m. So he said he took a nap during that time period. So when he's referring to 24 hours, I believe one of the things he's referring to is that it was 24 hours, and this would be logical in relation to what was being stated overall, that would encapsulate the time period while he was driving. And so based upon what he stated from his sleep aspect, other than a nap before he went to work, that he had not slept until his full night's sleep on the previous night. And so that would be the length and aspect of the fatigued aspects of the driving.
Did you say the forward edge was parked on the right shoulder?
Yes.
Was it a company car? Motorcycle?
That, to be honest, I do not know off the top of my head if that was company car or personal vehicle that they went to, that the construction workers went to the site of the active work zone to do.
It was stopped when he came in.
Yes, but it was associated with the work zone. So it wasn't just, a mere, my understanding, this is not a mere vehicle that's just happens to be there right at an active work zone, that this is part of what all's occurring.
And to correct, just to get a correction here, so he denies using marijuana, but admits to being up for more than 24 hours. And
Yeah.
also, from the previous question, he didn't call his employer at any point about needing to stop or pull over.
That'd be correct. We have no information, no evidence that he did so either through his own statement or through anything that was documented from the employer or any evidence that way. All of our evidence and information we have is that he just continued to drive and do his runs.
Why was it so important to be here today, especially a year to the incident, to the crash, or from, I should say, and then to clarify all of these charges? I know you mentioned, third degree.
Sure. There's a few reasons why this is important. We felt that was important to do. So in the first instance, this is not trying to think of the correct way to put this. The nature of these charges are extremely serious. And this is not the kind of driving event, even vehicular fatality event, that we normally see or has been well discussed throughout our prosecutions. It is not common to have active work zone fatalities in York County. Also, with it being a murder of the third degree charge that we had, those are more complex. They require more understanding. I know from being a prosecutor for 27 years and doing this kind of work, I know when you just put out an affidavit of probable cause, that there will be numerous questions that come in at numerous times from media outlets asking all the very questions that you asked. So one of the things that's better is to have those answered, because the questions you're asking are the very questions then that the public would have. And they're very serious questions, and they're very serious topics. So we want to make sure that we are fully transparent to the extent in law and ethics that we can be. We can't go beyond the affidavit, but to be that transparent, to be that explaining as to why we're doing what we're doing. With the delay, we knew that that is a question that, and responsibly so, that everybody should want to know. Why did you take so long? And then finally, there is an education component that I ended with that I want to remind individuals of, especially with it being today the 1-year anniversary, that we must take care and caution with our construction workers who are working for us.
And how difficult was it to sit down with all three families and lay out, the investigation as you've presented to us, and knowing that this was an instance of not only, impaired driving from lack of sleep, but also impaired driving from substances like marijuana?
So there have been some discussions that have occurred along the way, that there have been some updates made. One of the things that, unfortunately, because we knew there was an issue regarding, while it's lifetime statute of limitation for third degree murder and for homicide by vehicle. For homicide by vehicle while DUI and DUI, it's a 2-year statute of limitation. For summary offenses, it's a 1-year statute of limitation. So one of the things that we wanted to make sure to do was to be able to file charges within the time frame if we were going to, regardless of what those charges would be, that the evidence was revealing already that homicide by vehicle would be appropriate. Now, you don't need to charge the summaries to have homicide by vehicle, but it does better explain and inform, especially the defendant who we're serving these papers on, to prepare for their case when you are able to charge the summary offenses, because then they're able to see what the underlying vehicle code violations were that lead to the homicide by vehicle charge. They're able to tell that broken down in that form. We wanted to be able to file in that time frame. Getting the report, and we really appreciate the job that NMS Labs was able to do, getting that report this week, unfortunately, rather than getting to do what I like to do, which is every family member, we all come together, sit in a room, and slowly and carefully during that period of time we go through all of the aspects of what's going to be in the affidavit. Instead, I had to do that by telephone. And we had discussions by telephone yesterday that were very thorough. Everything that I'm saying here today, I did say to all the victims and answered all the questions, and all the things that you're asking are exactly the same questions that they had in wanting to know. But I'll be honest with you, I like getting to be in a room with people, and especially when you're talking about things that are involving, the death of their loved ones involving pain. I don't like doing that by phone. I don't. So this was not my ideal process, but they understood. They understood. We had to move in this time frame based upon this. And we did have a full, thorough discussion. And then one of the things that we're going to do, and that I mentioned about, is that based upon all that they've heard, because look, this is a lot of information. This is a lot. I mean, I'm sure that as you're sitting and standing here, that this information, you can tell it's complex. It's a lot of information to get in what still is a short burst. Next week, I said, think about it, process it. It's the Easter holiday weekend. Process this. We're going to get back together next week. They're going to ask even more questions. We're going to go over more process things, and we're going to continue to have these frequent communications because it's important to have. You know, victims put trust in us. People don't get to, well, they do get to hire us in the sense that's up to the citizens, it's up to their votes as to whether I serve as DA, it's up to any elected official as to whether we serve. It's up to the public. We are public servants. They are our employers. Everyone in York County, they are my boss. They are all of our bosses. The state, they're the people of Pennsylvania, they're the state police boss. They're our offices, our county detectives, every law enforcement municipality. We all work for the people. But victims of crime, it's not like they were able to come into our office and say, we're here to hire you. At their worst, most pain-filled moments, they wind up having to have us. And we ask them, trust us. That requires a busload of faith. And we deeply honor and respect that. I mean, to have people putting that trust in you, you have to demonstrate that you're worthy. You have to prove that you're worthy. I asked a lot of them over the last year. I did. I said, keep with us, bear with us. And there are times, and I think I can say this on their behalf, where I'm sure they wondered, were they abandoned? Have people forgotten about us? We never forgot. We never did. We never did. We never will. We just had work to do. And we said, keep the faith. They did. And we got answers. And you know what? If the answers would have been different, to where I had to sit down in a room, which I have to do many times, and say, we're sorry, there are no applicable charges, or we're sorry, charges only rise to a certain level, then we do that too. The most important thing that we can give is of ourselves. You can't call yourself a public servant and then not serve. And you must serve with love for everyone. And that includes with our role as being arbiters of justice. We serve the defendant as well. We will guarantee that he will have a full and fair process. He will receive all due process and have a full and fair trial if he so chooses to have a trial. Everything we do will be with the utmost respect for fairness and in the pursuit of justice. That's our promise. And that's, in the end, what we will follow through with and what we will do.
I have a question about the speed in entering the work zone. How fast was he traveling, and what was the speed limit there?
So it was 63 was what he was doing as he was going to the work zone, and then 50 miles per hour as he was going through the work zone. That's what we documented in the affidavit of probable cause. And what was documented through collision reconstruction coming from the data that was recorded from the vehicle. And I apologize off the top of my head, I forget the exact speed limit at that moment with any kind of changes. But overall, we didn't include a speeding violation as the underlying summary because, quite frankly, the ones that were the direct and substantial causes of death all related to the other citations that we filed. And we really wanted to focus on what we were calling the direct and substantial causal factors of death. The speed aspects become important, the interplay with the accelerator pedal and with what the different variations were occurring with throttle input, as noted, because it's showing that there was a lack of coherent driving that was occurring along the way. Well, if nobody has anything else, I know that you've been very patient with us and in listening to what we had to say, and I greatly appreciate your time. Thank you very much.